documents that we have proposed
Not because of this comment.
because of this comment.
And also, too, some of the suggestions that are being made would be the subject of a legislative change, which is beyond our pay grade in any event, so, I mean, like, the requirement of certain disclosures of all the cases you've ever had. I don't think any of that's a good practice, I don't think it's required, and B, if it's gonna be mandatory, then the legislature's gonna have to tell us all what it is.
I think just beyond the scope of what we're supposed to do, we could have a customized fee agreement for every practice area.
Well, that's up to the practitioners.
No, but I mean,
Yeah.
for this group to do that, that's beyond the scope. If the family law section wanted to prepare a best practices retainer agreement for family law attorneys, by all means, go ahead.
Yeah.
But there's a lot of subject matter expertise on fee issues generally, but is anybody in the room here today a family law lawyer? Do we have enough to have a collective wisdom to do it? I don't think so.
We're in the law of lawyering and billing.
Okay, let's go to our second comment.
Oh, wait,
Oh.
before we, isn't there, I haven't memorized the roster of sections now, but isn't there still a family law section among the spun off group of sections?
I think so.
There's gotta be.
There must be.
Specialization.
Why don't we also just say that, just what you said, which is in a response, say, if this is to come at all, maybe you should contact so-and-so, the head of the family law section, who might be interested in sponsoring some kind of task force to look into this. I'm done.
All right.
We can roll, you turn it over.
The second comment from Johnny Del Mar, who is an attorney, as a criminal defense attorney in private practice, sole practitioner, where clients typically cannot afford to pay hourly rates, a contract might look like this. So I was trying to sort of figure this out because it looks like that he's just providing us with a potential sample agreement for for rendering services for someone that's been charged with a crime in a flat fee situation.
Again,
Yeah, I mean, we cover that.
Yeah.
We already have the flat fee language.
Right.
The rest of this is, I mean, it's covers a lot of the things that are already in there. Responsibility of the parties, errors and omissions, service to be provided,
Cost.
identification. So it's a it's a different format than what we have. But if we didn't have a flat fee provision already, I'd say, well, that's probably a good thing to consider, but we already have that in forms, and I don't see any comment in here about the flat fee provisions or suggesting anything that's in the ones we have need to be changed or updated in any way.
right, he made that up to the thought.
Yeah.
I think we need to expressly disapprove this proposal. One section is self-contradictory. There's a flat fee that is fully earned, but if under some circumstance, the hourly fee is $350. Well, the whole section makes no sense at all.
I think he was trying to take into account the language about flat fees.
Yeah.
With
But he's doing it very poorly.
nobody said he didn't, but I'm just saying, I think that's what he's trying to address, and he thinks that because our suggested language may not have encompassed all of what he considers a change, he's suggesting it's not. I'm with Ken. We already have it. The lawyer can tweak it as he wishes.
I think Roy raises a good point. I know you need to disagree with it, but he says attorney's fees, $3,500 flat fee. Attorney bills at $250 an hour in the event client requests a refund in whole or in part. That's like a conversion of fees, notwithstanding the fact that there might be a dispute as to what had been earned. So the second part of the phrase seems entirely problematic to me. Not saying that you need to respond to this. I just appreciate what Roy raised, and also agree with Ken and Anahid that you guys already addressed this, and not only do you already address it, what you do is much more fulsome. All he's done is copy and pasted the rule. You've done this work already, with particular the errors and emission insurance disclosure. I mean, he doesn't even use the safe harbor language that's contained in Rule 1.4.2. So I'm not sure, unless anyone, unless I was curious if someone saw something in here that might be useful to add. But what he's proposing seems wholly problematic to me, or at least not as strong as the work you've already done.
Well, I agree with Roy. In the case I just testified in, the parties had actually attempted to identify an agreed-upon reasonable value
I
rate.
think that's,
In the event, you went from contract to reasonable value determination for any reason. And then the question presented to the experts was, is that appropriate? Can you do that in advance of there being a dispute? Can you have a stipulated reasonable rate? We were back and forth on that, and I won't tell you how it came out because we don't know the opinion of the arbitrator yet. But that takes a little more words than this. And we have to expand it somehow if we were interested in saying that that's something that we ought to be doing. So
I don't have a problem with the way he did or find it contradictory, because somebody might terminate the relationship before your flat fee charge is completed. In which case, as I understand the rules now, you haven't completed the flat fee for services and money is due back.
yeah.
And the interesting thing here, so the guy's charging $3,500 for this particular tenant, who says it's a $250 flat fee, $250 per hour. I can see a lot of instances where you get to the point the client says, I don't want you to handle this anymore. Well, I've already got 40 hours now, so I'm not really giving you anything back because I've gone above and beyond what any of us can.
well, but then that's fine, but if the client then still disputes it, the arbitrator or the judiciary is not bound by the $250 an hour. The ultimate trier can still decide that the services were only worth $100 an hour or $50 an hour. So, I don't know that it's that helpful to try to say, I declare that this is the reasonable value of my time because perhaps I did something that clearly establishes that the reasonable value of my time is nothing. Or it was, 250 or somewhere in between.
Yeah, and there's all the other factors too. Was it tainted by professional misconduct? Was it tainted by malpractice? Was it this? Was it that?
That's how we use.
And
define
also the
reasonable.
risk, the flat fee is a risk shifting device where you take the risk of overpayment by a client and you put it on the attorney. The attorney's got to be efficient to get it done. Now, how do you write a fee agreement which kind of alters that? You can't just do it except on a case by case basis.
Do you think this gentleman wants us to simply say, yeah, that sounds great, we're not gonna use it, or, I wouldn't feel comfortable doing anything. I think, again, we have in place all the terms that one would need to, have a valid fee agreement. If he or she wants to put something else in, that's fine. Obviously, it could be okay, it could be not okay, and nobody's gonna determine that until and if there's some sort of proceeding with reference to that, retainer.
All right, so I'm hearing that
Ms. Bob's dead too?
we have considered the comment, and we do not believe that there's a change necessary to the documents that we've already generated.
That sums it up.
Okay. We will now move on to, we're gonna go out of order here. So I'd like to jump down to item 4, which is starting on page 42, which is the Discuss updates regarding issue of arbitrator compensation and whether to revise corresponding state bar and model rules. Isabel, do you want to just talk about
Sure,
how this came about?
sure. Andrew, do you want to
Or
talk
Andrew,
about?
do you want to
Yeah.
talk about it, or whoever?
So,
You may recall, last meeting, you approved the revision to the LA County Bar's arbitrator compensation rule, subject to review by general counsel's office that 6,200 permits arbitrators to be compensated. And we sought that advice, and the Office of General Counsel said that arbitrator compensation is not prohibited under the statute, and so arbitrators may be compensated. But as part of that review, they thought that the model rule and the state bar rule could be clarified or better drafted to assure the understanding of the parties as to what their obligations are when they're going to compensate the arbitrator. And so, with some of their input, staff has offered a proposal to amend the rule, and we're seeking your input on that proposal.
So we have the current model rule, the suggested revision, the current state bar rule, and the suggested revision. I'll start. Just with the biggest thing that sticks out to me is this concept of equal time. I don't think that's like a feasible concept at all. It reminded me of it.
Would you repeat that? I didn't hear.
So this concept that it says that the arbitrator is not permitted to seek compensation, and the arbitrator shall ensure that each party is offered equal time to present their case. So as I thought about it, it harkened me back to when I go down to the Superior Court and do the mock trial judging for high school kids through the Constitutional Rights Foundation, and there's two scores or two timekeepers that are sitting over in the clerk's chair, and they're like, the prosecution has 3 minutes and 40 seconds remaining. The defense has, and someone literally is sitting there and making sure that they each are using like basically a certain amount of time to present their case. In arbitrations, it's just not possible. Especially like as a sole arbitrator, even if it was a panel, it's like you don't want people sitting there like, with a stopwatch, marking time, notations down, as opposed to like listening to the parties. So, I mean, if the arbitrator is doing their job right, by the time you finish, each side should feel that they've had ample opportunity to present their case and their evidence and what they want to say. And, at some point, the arbitrator is like, okay, we're done here. Like, we're going to take it under submission and render a verdict or opinion. So I don't know where the equal time concept came from, but I just don't think that that's like practical.
Yeah, I had some concern about that, but I think I know where it comes from, because I've been contacted about this on occasion, where, a lot of arbitrators will set up their hearings, so it's like in the afternoon, planning it to be 4 hours. They won't really discuss the fee issues, but they kind of view 4 hours as what they're obligated or the max they have to do. And I've been contacted in the past, I've actually experienced this at an arbitration where 80% of that 4 hours is given to one party and not the other, and then they just kind of cut it off because they're at the 4 hour period. So I think that's where the concept to some extent. I don't think that, I was a little concerned about the language shall ensure offered equal time as opposed to, something along the lines, if, even if there's not, compensation, the arbitrators, shall see that the parties are afforded an opportunity to present their case. That was kind of the concern I had on that last sentence there, which I think was meant to be proactive, that they'll retain the authority to control the total length to ensure there's a fair and thorough hearing. But I could see the statement about retaining the authority to control the total length being asserted by arbitrators saying, I'm doing 4 hours and nothing else, and without necessarily giving the people the full opportunity to present their case. So I was a little concerned that that could be used more as a, the shield or sword or whatever by an arbitrator to kind of cut things off, so.
Okay, Joel?
I think I voted against this the last meeting, and I continue to remain against compensation.
No.
Parties want to agree to compensation, fine. I wouldn't put it in the rules. That having been said, I would remove the word equal time, and in light of the last sentence, just say appropriate time instead of equal time. Because what you're saying is the overall objective of the last sentence is to control the total length of proceedings in order to conduct a fair and thorough hearing. So I think appropriate time is better than equal time because it's artificial. I mean, one person might be testifying the dog died. Another person might have to testify for 10 hours for 10 reasons why the dog died. But, it's not going to be equal in terms of time, so it should be appropriate. The second thing that I would change, and I don't know quite how to change it, is you've got a rate in this thing. And without a committee such as ours to be babysitting this, that rate is going to become inappropriate over time. And there ought to be a statement of how that rate gets changed, short of somebody having to go to the State Bar Board of Trustees and asking that that rate be changed in light of the, cost of living index or whatever. So if it's going to be COPRAC, if it's going to be somebody, we ought to put in there at a rate set by, or $150 for each additional hour, or such a rate as may be set from time to time by X, by COPRAC or whatever. That would make this a little more workable. But beyond that, I'm still voting no. Have fun.
Well, with the rate, I understand what you're saying, but unless I'm missing something going forward, if somebody wanted to change either the model rule or their local rule to adjust that rate, they've got to submit proposed rules, and there will still be some process. Granted, it's not this committee, but somebody will be vetting those and then making their report to the board. So I think it'll still hopefully be there. But
you're right, Ken. There is a clear path still for a local program to get its rules approved. But the default, of course, is the model rules. The model rules say 150. Now you're stuck unless it goes to somewhere else. So I think that to make this more workable, not that I'm favoring higher compensation, but to make it more workable for the future, there ought to be a designation in the model rules which says where you go to change this cap when necessary. And I don't know what that is because I don't know enough of the two structures yet. So that's.
I guess my concern would be that might be. I'm with you on the charging the fees. To the extent that that's in there, that kind of opens that door and perhaps encourages going above the 150. But.
Yeah, well, I'm happy that it stays chiseled in some stone somewhere at the foot of the Supreme Court building and 150. That's fine. But I think for those who favor this, there ought to be a practical way of dealing with it in the future.
So can I just comment to that last point? I would advise it against putting in the procedural aspects of how to change the rule. It may not be COPRAC one day. I know you recognize that in the sense that we don't know,
Yeah.
who or what will be around in the future. But I mean, I take your point that the rule may change, but how to change the rule will always remain the same. It needs to be presented to the board. So, whether it's staff, whether it's a local program with petitions, there's a variety of circumstances. So I would advise just being silent on how to change it, but we should be sensitive to the fact that it might need to change one day.
Andrew, works for me.
And then, sorry, Roy, I'll just, with the equal time, maybe we should just focus on that since that's where we are. I mean, I'll just say where it comes from. It is offered equal time, not that equal time is required. I mean, I take your point. I'm not trying to say I disagree. I'm just trying to explain where it comes from. You have to ensure each time has equal time. Because as you say, someone might not have the evidence to present, and it is rounded out by the last sentence where the arbitrator, retains the authority to control the length of the proceeding. But the point of that is to go to somewhat of what Ken is saying. If someone has the majority of the 4 hours, the 4-hour mark comes, one party says, well, I'm willing to pay to go on. The other party says, no, I don't want to pay, so I'm going to stop at 4 hours. The way the rule is drafted is intended to avoid someone conscripting the other party's ability to present evidence. I understand that may not be how it is in reality, but whether it occurs or not, that's where the concept comes from.
I understand what you're saying. Look, equal time, like for me, being in the broadcast business, has a very specific meaning, which means that if a Democrat is gonna get 3 minutes, then that means that we've got to give a Republican 3 minutes. And so when I read this, that means that if the plaintiff or the petitioner has 3 minutes, then the respondent has to get 3 minutes unless someone wants to waive their time. And I mean, getting into that really pulls the whole thing out of this. This is a very informal process. And so putting a formality to it, and I take what Ken is saying, I understand what Ken's saying, and I get what the concept is that it's trying to sort of deal with. I just don't know that this covers it, because it's almost as if the arbitrator needs, part of the arbitrator's role is they should be controlling and making sure that each party has received, if they're only going to do it for 4 hours and that's their cutoff, then they've got to make sure that everybody has the opportunity. They've got to set up the proceeding so that everybody has an opportunity to be heard. Anahit?
Yeah, and I don't, to have language that says equal time, something like that, I think is going to allow someone who reads that to assert that he or she needs to be given, if the other side had 20 minutes, I need to be given 20 minutes, even though I have nothing to say. Or I have irrelevant, as arbitrators, we know a lot of people come in, even the attorneys, and start telling us about all sorts of irrelevant things.
Filibustering.
It's so difficult. She came into my office, cried all the time, all of this stuff. Well, sometimes maybe that's relevant, I should say. But, a lot of times that's not. Or, she was so mean to me, and she knew I was, my husband left me, my wife left me, I was very vulnerable, and she was not nice to me. Well, I don't know that that's something that we need to take up. After I'm so sorry that happened to you. Is there anything you'd like to offer that's relevant to this previous case? And then do we get our arbitrators in trouble because, again, petitioner was given 20 minutes, respondent was not. So I think it's clear on the duties, and I'm gonna shut up now because I see people are raising their fingers and their arms. Their appendages are
Okay,
going
we're
up.
gonna go to Patrick and then come back to Ken.
Here, I've tried a bunch of cases where it was very, very clear the other side was trying to run the clock really short.
Sure.
And it's scary when that happens. And then when you talk about the rules for vacating arbitration awards where people don't get to get their evidence in, and that's a ground for vacating it, you create some tension. So, you know, the rule I can see, there may be a better way to phrase it so it's more aspirational and doesn't create guarantees that people may try to leverage. But I also think as an arbitrator, it's a good idea heading into the arbitration. So guys, we're scheduled for 4 hours, and each of you are going to basically get 2 hours. So frame your arguments accordingly, so that people where they can't filibuster for their own benefit, and that the other people start figuring out what's actually relevant and what's not relevant.
But that's what we're supposed to do anyway.
What I'm saying is by telling them in advance, then they're forewarned, and it's really hard for them to later come back and say, oh God, I was taken advantage of, I didn't know. In other words, you put in your notice to the hearing, the hearing will be 4 hours, each side will plan that they'll have X percentage of that, you know, an hour and a half or an hour and 45 minutes to present their case. They know going in and they can't argue about it.
But what I'm trying to say is, isn't that what we're supposed to do anyway? Regardless of what this normal rule says?
I guess what I'm saying is give them notice of it, and then still do what you should be doing. You know, two different approaches, same problem.
Okay.
Well, the third, I'm sorry, go ahead.
Rick, there's at least one judge in LA County who has a chess clock on his bench.
It's not one, there's lots.
I say there's at least
Oh, I missed that.
one that I ran into,
I take my glasses off.
to be a problem.
At the same time.
I fully support Joel's suggestion of changing that word equal to appropriate. You know, I've had cases where one side has needed a half an hour to cover a particular subject, and the other side disposed of that subject in 2 minutes. We don't need equal time to have appropriate time, but we do need to avoid eating the clock on one side.
Well, yeah, and also too, one of the things that we're trying to guard against, and I don't want to disparage any arbitrator who's ever handled one of these, but there are arbitrators who will, oh yeah, bring on that extra motion, I'd really like to hear it, because we're coming up on 4 hours and I'd like to spend more time with this, like getting the compensation. There might be one lawyer or arbitrator who does that, but in that case, I think appropriate is much better than equal, because now the arbitrator can say, well, wait a minute, they spent 2 hours talking about how Aunt Tilly didn't do so well in the, Kentucky Derby, but now we got to give 2 more hours, and by the way, that's compensated. So,
Oh, Ken.
Yeah, well, Patrick touched on what I was gonna say, though, but yeah, that's my big concern, is it sets up grounds for vacating award when we say affirmatively shall ensure equal time. If the arbitrator doesn't do, he had 2 hours and 20 minutes and I had an hour and 40 minutes, arbitrator breached the rule, vacate the award. It's just, that's a practical problem. I agree with the first part. I mean, I like redoing the rule, so now that it makes, the way it was written, it was almost not necessarily mandatory, but it was, it was gonna happen at 4 hours. So I like that this makes it more discretionary and puts the obligation on the arbitrators to do it, at the front end, which is what we've always encouraged in the training. Maybe on that second sentence there where it's, talking about the shall, is not permitted to seek compensation, but will permit the parties to appropriately present their case or something like that, but.
George,
So,
you had?
Back to the Joel point about appropriate, this whole thing is supposed to be client friendly, right? It's supposed to protect clients' rights. And back to the point about the mock trials and filibustering, because filibustering happens in mock trials too.
Mm-hmm.
And I can see it easier for a lawyer to filibuster for 3.5 hours, and then
Do we think that if we took Joel's thought of changing equal to appropriate, but added in that sentence, at the end of that sentence, picked up on that concept of like the fair and thorough, so it's in
Yeah.
both places maybe, like that it just sort of, or move that up, that it just punctuates, just that the hearing should be fair and just to both sides, or just.
One thing I liked
As
about the
opposed to
last
how it would be
sentence,
without the model hearing?
the one thing I liked about the last sentence is that it wasn't connected to the compensation. So you don't have to pay to get that. I like that we're separate from the compensation concept by being in the last sentence.
But this sentence talks about what happens when the arbitrator is not permitted to seek compensation. Then each party's, offered appropriate time to present their case. I was suggesting so it is to ensure, a fair and thorough hearing.
Oh, okay, I see what you're saying.
What
I was
would
just bringing that
suggest-
concept up again, but what?
Maybe if we just, where it says now, then the arbitrator is not permitted to seek compensation, just put a period and then take out the rest of that sentence. And then that last sentence takes up or addresses that issue of,
Yeah, I
appropriate
like
time.
that too.
Because that last part of that first edition is where I see the problem. So just say, yeah, the arbitrator is not permitted to seek compensation for a time beyond 4 hours.
I like that.
Yeah, I like it too.
Another interesting wrinkle here is,
Everybody like what I said?
how many arbitrations do we see that go over 4 hours?
Not mine.
Not mine.
Good job.
Not if you're doing it right.
One in 15 years.
Yeah, I mean, I've had a couple where people tried to turn them into 8-hour marathons because they were a couple of nuts who thought it was a federal court case over 40 grand, but otherwise it's like, an hour and 45 minutes is a really.
It happened, it happened.
My last
Especially
one, I think, was
Beverly Hills.
5 minutes.
Yeah, they had
Well.
2 weeks, 3 weeks, yeah.
I mean, some of these that are like multi-million-dollar cases,
Sure.
like obviously those could go on for
Sure.
days. But yeah, I've done this for 20 years. And
Yeah.
I've had one,
That's what I've been,
and
I've had it for 20, I've even had cases where there have been multiple issues of malpractice because this, talk about knucklehead attorney, 6 different cases, no waivers, it was ridiculous. Still, we got it in and out. I told her to take her however many boxes with her as she leaves. So,
If we talk about the multi-million-dollar ones, in my view, those really aren't well suited to the arbitration because almost certainly one side or the other is gonna react. So then to turn into entertaining these people for multiple days on end when the writing is on the wall that massive law firm against massive sophisticated client, both with sets of lawyers.
But they, just to count it a little bit, I mean, I have seen those where they wind up resolving, even though it's non-binding.
Okay, that's for another day. To round
Somebody-
this out, I move what
Okay,
Ken
yes.
said.
all right. So Ken, what is your?
Second.
Webster Jam, it was
What is
period.
my amendment?
Then the arbitrator is not permitted to seek compensation,
Period.
well, it's either period or for time beyond 4 hours. Either, I'm fine with either way. And then you just leave that last one.
So
I'm sorry,
what-
did you?
what-
No, you have to give us something that we can make a decision about,
Yeah.
Okay.
either or.
All right.
I would say it's not permitted to seek compensation for time beyond 4 hours.
Is not permitted to seek.
Right now, it says, then the arbitrator is not permitted to seek compensation, and then it goes on, and the arbitrator shall ensure blah, blah, blah. So instead of the and ensure blah, 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 either to put a period there, or for time beyond 4 hours, either way, I think works. So
I adopt the second one, that's my motion.
I thought we were
So
talking,
Joel's motion is the second sentence of the model rule. If this agreement is not timely entered into by the parties, comma, then the arbitrator is not permitted to seek compensation for time beyond 4 hours, period. The rest of that sentence is deleted, and then that's
then the last sentence stands as is.
Yeah, the last sentence stands as it.
Well-
We're leaving it in the bracket exact, so hang on, we'll come back to that. I just wanna make clear, Ken, also you had the suggestion about appropriate time being included in the last sentence. There's consensus to not amend the last sentence to deal with appropriate time, just leave the last sentence as proposed.
Fair, yeah, I think fair and thorough, very enough.
Okay, okay, and then,
Prior to taking that.
sorry, John, before we leave the topic.
Yeah, John?
What I've been hearing for the past few minutes sounds like the arbitrator is entitled to compensation after 4 hours. Now the motion is on the floor.
Mm.
No, no, no.
It was, the rule as it exists now kind of implies that once you hit the 4 hours, they're entitled to it. This
No,
is
I-
making it more discretionary.
He misheard, I think he misheard. The arbitrator, there has to be, an agreement with the parties that the arbitrator will be paid. If not, the arbitrator will not be paid. Yeah.
Yeah, and that's the suggestion, I guess, of general counsel, so.
I think that's making that decision be made before the evidence begins allows everybody to also be pretty frank about what they can present their case.
Yeah, I didn't
Sure.
realize that was in bracket.
Yeah,
Okay, so, right,
so
as in
that
brackets,
was-
as an alternative, it's a question for your expertise. Do you think there should be a timing element as to when the agreement should be entered into? Or should it be silent to allow the arbitrators and
Wiggle
parties
room.
to
It should be,
agree?
yeah, it should be.
Before
Yeah,
anybody
I
plays
think-
the game.
Yeah.
Leave the
I-
bracket
Is,
language in.
is the phrase prior to taking of evidence, is that appropriate A time, and B, is that statement
Yeah, so
correct?
that's the language we use,
Yeah,
if they're gonna
or
stipulate
stipulation.
to.
Binding.
Right.
Binding.
That's where we took it from, so it's consistent.
Yeah.
The nice part about that is if this agreement is not timely entered into, it's supported and applied, you accept the practical language, that would help in this sense.
I move to amend the motion to make Bible Rule
What we said.
38O and State Bar Rule, D identical.
Okay, so that's,
To transplant the language from the model rule over to the state bar rule. It's the bar,
the state bar rule is written in a different,
Yeah.
can we tackle that motion
Yeah.
separately?
I would draw.
That's a different conversation.
I would draw.
Okay.
Okay.
Okay, Ken's motion, I think is still on the table for the changes to, the revision to the model rule 38.0. So, let's just recap. Bracketed language and in the second sentence will be accepted. So prior to the taking of evidence will be part of the sentence. The third sentence, starting with if this agreement is not timely entered into by the parties, comma, then the arbitrator is not permitted to seek compensation. We're gonna add for time beyond 4 hours, period. The rest of that sentence is stricken. And the other two changes, if agreed to, in the final sentence are accepted. That's Ken's motion. Do we have a second?
Second.
All in favor? Aye. Anybody opposed?
Yeah, I'm opposed under protest. Going back to my prior vote. But that's okay.
Loyal opposition.
But if you had to approve it.
If you had to
Right.
approve,
Twist
yes.
my arm.
No vote, no vote.
Do you need anything else?
No, but Roy had a motion to
Okay.
transplant those changes
But we're
into
not
this.
gonna, okay, so now we're gonna do is we're gonna flip the page to the current state bar rule, which had different, it was worded differently. So let's now, you can look at what we just approved, and we can now see if this works over here.
You know, one, you should all review the state bar rule. One easy approach, if you agree, is to just direct staff to make the corresponding changes to the state bar rule. Because the state bar rule is drafted different than the model rule, which goes to Roy's point, might be a separate. But we've made some line-item edits, we've captured those, if you are trusting of staff. We can make the exact same edits as interposed with the state bar rule, but I guess it would be prudent, just read the state bar rule as is, and we can make the corresponding changes to the form and format of the state bar rule that you guys just approved in the model
the only substantive difference is in the state bar one, it talks about the driving competition.
Mm-hmm. And the schedule
So
of
if I were saying
charges.
prior to the, and let me just read this out loud. If the agreement is not entered into and not timely entered into with the parties, then the arbitrator is not permitted to seek compensation for adding for time
Beyond.
beyond 4 hours period, deleting the remainder of this sentence, and then no other changes to the way
Well,
state.
The proposed draft here has that next sentence, that's deleted in the other one.
No compensation.
Well, this one has the red line, no arbitration, no compensation, or the honor rule, but it's still, oh, no, wait, it is good.
It is. It's just a.
Oh, yeah, no, okay, I'm sorry, I missed
Like
it.
if you're looking at.
Yeah. Yeah, no, that's, no, I just heard this reading.
Yeah, okay, okay.
So do you have a motion? You wanna make one?
Sure, I make the motion that we have staff, have staff.
Make the
Make
corresponding
the corresponding change
To the state bar
to
rule.
the state bar rule.
All in favor?
Aye.
Any opposed? Joel's not here.
Neil's not here.
He was gonna vote no
Joel
or
stayed.
abstain.
But if you was here,
All right,
Alright.
we good?
Yep.
Okay.
So we have 20 minutes. Do you want to start on the program advisories, or you want to tackle something else? Maybe these two, or you want to start on this? 'Cause this is kind of long.
All right. We will, but 20 minutes until lunch, so let's see what we can like move through. I think we can just, let's go to the, just the, it's a very quick update, which I can give. Let's go to item 6, which is my, I started this whole thing.
Is your tree killer?
This is my tree killer. So this is the Sony versus Tyranny Simple Players case. So I just wanted everybody to have the latest update. The respondents finally filed their brief opposing the Tyranny's appeal of the trial court's decision in the attorney's favor. As I understand it, they're going to file a final reply brief early July. It'll go for oral arguments shortly thereafter, and then they're hoping that it'll get a decision by the end of the year.
and I think someone should show up.
Do you have an actual argument day yet, or you just?
Not yet. He just sent me in a note and just said that, like, I was just asking him, like, what's the next sort of, if you do what Isabel, like suggested, if you really want to follow the case and do the auto notice every time like something pops up, like you just get an email, which is actually kind of cool because it'll tell you like exactly what happened. And
I've been getting those things, and
You know
I couldn't figure out what case it was.
who was this case?
Now I remember why I signed up for it.
Yeah.
Do you remember you actually signed up?
I do, yeah.
Wow, impressive.
So it'll be interesting to see, what happens with this. I mean, one of the big issues I think in here is Anahit's favorite issue is like, what happens with this 5-day, period? Is there a 5-day grace period? Is there not a 5-day grace period upon the service of the award?
Case law was pretty clear on that. But it seems to me what they're doing in the respondents group is, and maybe, I don't know if we need to consider that, that they're piggybacking on tolling of the statute of limitations under 6306 to
When you file in court,
equate that with the trial de novo issue. And that's kind of
noticed
apples
that
and
too.
oranges to me. In the case law that's existing, this side of the appellate brief, I thought, well, that was pretty well decided, it's more like an appeal, jurisdictional 30 days in, 5 days does not apply. That's apples and carrots, apples to oranges is fruit to fruit. That's true
know.
Waiting until the last minute to do it.
Like, why do they file on day 32 or 33, whatever it was?
Yeah.
Like everything else in the practice.
Burn.
I found it intriguing that the zoning firm has been down these roads.
Yes.
They've definitely been down these roads
at
before in
least.
connection with whether people that work at that firm are actual employees or they're independent contractors. So this is just an interesting one to like continue to watch.
Well, it's not an independent contractor, because, we all have independent, usually they're attorneys. So we can't be employees and dictated to by an employer.
Let's go to page 100. Hopefully we can knock this one out kind of quickly as well. We had talked about just putting out a program advisory in connection with the discontinued use of the arbitrator handbook. This was the issue that came up in that Brock versus Baxter case where they were citing this handbook that hadn't been updated forever. And that we're concerned that local programs might be still pushing it out, and it's just not a document that we were constantly updating with case law changes and whatnot. So I kind of just made it very, very simple in that
Don't look to this because
it's just not relevant and not being updated. So does anyone have any comment on the potential advisory?
I think it's well written and it should include.
Oh, thank you.
Okay.
Wow.
My-
You didn't have a change to something that was.
My only issue is I don't know that the local bars use this. I know that the state bar used to use it and we discontinued giving it out to our arbitrators, but there might be copies out there floating around. I don't know for a fact that the local bars have the equivalent or have the same thing.
Well, some have, membership is right, because I think it came up in the Fox case, that the county had its own handbook.
Okay.
We don't necessarily control that.
But that was the state bar
But it was
case.
the citation of the state bar's handbook
Mm-hmm.
that we don't use or update anymore, that we cite for some kind of control.
Okay.
it's identified as to which one it is.
Yeah, this is talking about the, this is talking about the state bar.
Right, because it was a state bar fee arbitration, the Bach versus Baxter case.
But I don't
It
know if
was-
we can legislate, if county bars have their own handbooks that they're using in some fashion.
Mm-hmm.
Even if it's, they just piggybacked off of the 2005.
Mm-hmm.
That was, like, I think that was my only, I don't know, was it just 2005 that we had this? I don't know. I started in 2007, they had a handbook before that.
Yeah, I remember when I first started in 1993, we had the handbook, and we went through it, and we would have an annual nitpicking contest. Who could pick out the most commas and stuff to change with that handbook? And it turned out we just gave up. We just gave up years ago.
We might want to take out that first quote, it says in 2005.
The 2005.
BMFA had issued the arbitration handbook and all.
From time to time,
I move we adopt the conclusion. We don't need the rest.
It's consistent format with the other program advisories. That's the only reason why it has.
explain to people why. it
Well,
is.
I thought about that. I mean, when I asked Isabel, when she reminded me, like, I was supposed to do this, I asked her, I'm like, can you send me the format? Because I don't remember them. And then when I saw the format, I thought, because initially I was like, I sent a note to Ani, and I was like, well, this is like one sentence. Like, this is easy. And then when I saw the format, I thought, well, maybe it does require a little bit of, like, history and, like, just.
Well, I think it makes it clear too. I mean, it's kind of like if the legislature, passes a law to circumvent a bad case decision. I mean, we're saying here that what happened in that case where they were using this whole thing, we don't want that to happen again. Don't use our handbooks.
So the comment I heard was we would take out in 2005, start that sentence with the CMFA, paren the committee, has issued a fee arbitration handbook from time to time for use by arbitrators conducting mandatory fee arbitrations throughout the state. I'm gonna add a space between Baxter and that parenthetical in the next sentence. And then, I think a comma needs to go in the last sentence after code. With those changes, any other ones? So I'll make a motion to, can I make a motion? No.
Yes.
I guess I
Can
can.
you?
I can make a
Yeah.
motion to accept the advisory as just described. All in favor? Any opposed? The motion carries.
All right, we have advisory
We have,
27.
a program advisory. All right. Where should we go now?
Do you want to do final number 2, finalize updates
Okay,
to
let's
arbitration
pop up to two.
advisories?
This is Ken and Joel, finalize updates to arbitration advisories. Attachment 5.
Oh, okay, yeah, we just added the summary and the Shepherd Mullins, so the section on the handling malpractice, by the dealing with violations of rules of professional conduct. Rather than updating the rule references, that includes basically the summary of the Shepherd Mullins case, how that touched on this issue.
So I had a question, and in the added paragraph 2. So I guess starting with the last sentence, it says the court remanded the case and held that in asserting that separate page
17.
The court remanded the case and held that in asserting such separate equitable claim or cause of action, Shepherd Mullen would have the burden of proof, and that it would have to show, among other factors, that the 1, violation was neither willful nor egregious. 2, the firm's conduct was not so potentially damaging to the client as to warrant a complete denial of compensation. And then it starts a new sentence. And then, so what happened? I feel like something.
That was a correction that was made that didn't get picked up.
Okay.
Oh.
So what's that supposed to be?
There was a 3.
Well, there's a 3 here. So what's that supposed to be?
The 3 should just be another clause of that sentence.
So was that supposed to be denial of compensation, comma, or not a period?
I would,
And
after compensation, strike out everything through the, or up to the semicolon.
okay.
Compensation, semicolon, and 3.
Yeah, such a word does not undermine the sentence.
Okay, I think that when you go back up where you guys before the 1 where it says that the needs to go inside the 1 because otherwise that you should be able to read and finish each of the numbered areas on its own.
No
And so
objection.
if you say that you follow what I'm saying?
No
Mhm.
objection.
And then
Okay.
the firm.
Yeah.
Yeah. Mhm.
Those were my thoughts on my comments. Otherwise, that was great. Rendition of that case.
It was a winner, wasn't it?
Everybody still reading? Anahid needs equal time.
No, she needs appropriate
She
time.
needs the appropriate time to read.
Okay, so over there where it says surrounding, did you get that? Surrounding that violation,
Where are you?
okay, so,
Which page?
yeah, no
Page
matter
16
the
or 17?
circumstances, it's still on page 17, somewhere in the middle.
Okay, so okay.
No matter the circumstances surrounding the violation, the ethical violation, I don't
Oh yeah.
understand that.
Okay.
Okay.
So striking the first violation. Space here.
said it was brilliant in the email.
Yeah.
Not so brilliant.
Of course, I hadn't read it before I told her it's brilliant.
No, your eyes sometimes scare when you see it and you think it's like, I don't see so much.
Do without using old directions.
I think they lucked out big time.
Do you have anything more on it, or?
Oh, no, I'm sorry, I just was thinking and.
Okay. Any further comment besides the ones that we've identified? Is there a motion to accept the changes as identified? All in favor? Any opposed? Motion carries.
Alright.
Congratulations. You think so?
The arbitrator? Oh, the new attachments? Okay.
All right, we're gonna
Okay.
we're gonna try to do one more. Item 3, review and update model rules for fee arbitration and mediation.
Is that the one? No, I think it's under
No.
5.
Sorry, it's number 5. Attachment A, page 45.
So yesterday Ken noticed that, or he remembered that the minimum qualifications of arbitrators were updated in 2017. I guess the committee worked on them during their December 2016 meeting, and then it was approved by the Board of Trustees in March 2017. So you should have received a updated attachment 8 that's supposed to replace pages 49 to 50. If you don't have that, I have extra copies up here. So this is the version that was approved by the Board of Trustees in March 2017. Did you-
It's actually, the original one was attachment 11. No, that's the.
No. They're both attachment 8. It would have started on page 49. Yeah, 49 to 50.
Oh, yeah, 49 for the minimum qualification.
Mm-hmm.
And the part on, that I caught was on page 50. It says no applicant shall have a tenure position of this 49 or no position of this section of this state law. We changed that back in 2016, 2017, when we had that situation where applicant had been state bar
I go back on the record
Yes, sir.
for our afternoon session,
Oh, on May 21, I'm available if you,
May 31st.
that's what I meant. If,
Please talk to Isabel after the meeting.
because I'll forget, I'm old. I forget things.
Okay, so we're gonna go to business item 8, review and update program handbook. Not to be confused with the arbitrator handbook, which we have decided not to update or
Or use,
use any
or
further.
acknowledge as existing.
So let's see, this was Clark, who is not here, but George, you are here,
And I'm here.
and Isabel is here.
I had a
So,
convers-
oops, I just marked on you.
Oh, it's okay. I'll lick it off.
So I'm gonna turn it over to you guys since
Okay.
you hopefully have a
Yes, this was a joint
roadmap.
effort by Clark, George, and me. Me. So I talked to Clark yesterday. He's unfortunately sick with the flu. He said that his edits are pretty self-explanatory. What I did was I just went through and updated references to the Board of Trustees, changes to the fee arbitration program location and the name. There are changes to certain departments at the State Bar. So the out-of-state attorney arbitration stuff, I'm not sure how we want to handle that because they're transitioning to online system. George tackled the arbitration advisory on mediation, which is a big one that needs to be updated. And then there's also, he also reviewed the bankruptcy 123 as well as 27. There may have been new law and disclosure requirements. So I tried to streamline this by adding the 3-page index so that you can see in a nutshell the changes that 3 of us found, but we included the text of the advisories that we didn't find any changes just in case there's something that we missed. So we can handle this however, whatever order you want, however you like.
And just to add a little bit on advisory 6, so the idea was to incorporate 1129 in there without changing anything of substance, other than the addition of 1129.
So I think I would suggest let's just flip page by page. Let's look at the changes.
Okay, in numerical order.
Let's just go in
Okay.
numerical order. So I think we can then start on page 104
Yes.
or
104 is
104 is the
yes.
first one. So it looks like we just deleted the word department and just changed it to the word program.
Right, because the fee arbitration program is under the umbrella of the Office of Professional Competence. So sometimes it's referenced as the Office of Mandatory Fee Arbitration, other times it's referenced the Fee Arbitration Department. So we should probably standardize a reference to the fee arbitration program since we're under the Office of Professional Competence. That's just a suggestion.
Is this one, because it talks about adopted the enclosed guidelines and then the qualifications, so, but this advisory doesn't have, so is it actually attached to the
Yes,
advisory?
it's attached as an attachment, and it was not enclosed because it was supposed to be revised again, but then you brought to our attention that it was updated in 2017. So we will swap out the 2010 version, I think it is, for the 2017 version in the final program handbook.
All right, any issues with 104? Okay,
This might be cosmetic.
yeah.
On the bottom of page 104. Thank you for your attention, and please do not hesitate to, may we change rely to contact and drop the word on. Please do not hesitate to contact the mandatory fee arbitration program staff for questions or policy guidance on other fee arbitration issues.
Oh, yeah.
Yep, that makes sense.
You can't count on.
Yeah, you never know what the next minute is.
It's non-substantive, but it makes me.
Yeah, that's good. So but I think what we'll do is like, we'll just gonna go through these page by page, and then at the end, we'll adopt the things that we've decided to do, just in one fell swoop. I think it's easier.
Okay.
Okay, so on to page 105, which is Program Advisory 2. I don't see any changes. On to page 106, no change suggested.
I had a question on that one,
Okay,
and maybe Andrew can answer that one. Because in the first paragraph talks about, we still have jurisdiction to proceed if the attorney is inactive. And I assume that's the case if it's the client.
What page you on? I'm sorry.
106.
But if this is one where the lawyer has requested or has a provision requiring the client to participate, can a suspended lawyer request fee arbitration?
If there's a court order, I think,
I
as
don't
long.
know. I know Rule 9.2 deals with what suspended lawyers can and can't do and what they should inform their. This advisory doesn't draw a distinction between the client initiating against an inactive lawyer or an inactive lawyer initiating. And I don't know the answer.
Well, Ken, intuitively, if you say that an inactive lawyer can't enforce a contract made while they were active, the mandatory fee arbitration, you're punishing both parties for the sins of the attorney.
No, it's the attorney. I'm talking about if the attorney wants to initiate fee arbitration.
Yeah.
And maybe assume they have a clause that requires it. To collect fees when they're, suspended. I don't know if that's.
So in other words,
I think I get what
proposition
you're
is-
saying, but that's not a client-friendly thing, so to speak, to let an inactive lawyer seek fees.
All right, the proposition is that if I am designated as inactive for any reason, then I lose my right to force my client to go to fee arbitration
Okay.
about my demand for a fee.
Yeah, and I'm just throwing that out. I don't know the answer to
Yeah, I
that.
don't think that's right, because it's still a contract, if it's not been
So
validated.
to Sharon.
Oh, so sorry. Oh, that's all right.
I've seen it as the state bar puts it in as a part of the discipline, that the attorney suspended or inactive or whatever has to initiate the arbitration if the client made a complaint that involved over the fee. So I don't think that you can take that away from the attorney.
Well, the difference in that one is where they're being ordered by the state bar to do that. I'm talking about a situation if let's say it's a suspended lawyer or disbarred lawyer who had a fee contract that required a client, but they want to collect fees. Do they lose that right? Because I don't know the answer. I was just throwing. mean, that's fine, that's pretty much what we did in the, it just needs to be added into there.
So in A,
To get the statute revised like that, and so far it's not it has not happening. And that was part of the debate, was how you go about, there's a one appellate court case that talks about you could just file with an arbitration program. There was another one said you in essence had to file a petition for arbitration in court if you wanted to do it. Then another court said, no, that's a waste of time. So that whole issue is kind of unresolved. We tried to revise the statute to direct that, and it's been in limbo.
but I think BME still has to be corrected to.
It has to be correct, yeah.
Yeah, lawsuit or,
Or commencing a trial arbitration,
Yeah.
contractual.
And then
Pursuant.
he has to, if client files in
Or
court,
pursuant to
or
contractual arbitration
pursuant
clause.
to contractual arbitration clause.
Is set forth in the fee agreement? Is set forth in retainer agreement?
Yeah, pursuant to the retainer.
Mhm.
Cause that's the only way you would have,
That's the clause.
yeah, that's the only way you would go to turned on, it
It
turned
keeps
itself
turning
off
off.
again. I didn't touch it, but it did turn itself off. It had it.
It
Yeah,
was
it
trying
heard
to
enough
tell you
from me.
something.
Yeah.
See, it's still trying to tell you something.
It's turning itself off. I don't know. Yeah, battery must be.
You're wearing out the battery. If we're gonna
It's not-
nitpick this, we also have a problem with paragraph G. Under the non-binding arbitration, client petition the court to confirm the orders of judgment. That's not correct.
Yeah, can I ask a question? Go back for a second. Like, what is the purpose of this 2 pages?
Notify the parties, I'm just gonna speak louder, to notify the parties of their rights.
But what I'm saying is, we have the client's
This-
right.
yeah.
We have the client's right to. We have the notice of client's rights after fee arbitration, like it's laid out.
Okay.
What is the purpose of this program advisory to Sharon or Elaine or Sonia or whoever? What is this? What are they getting out of
We
it
don't need it.
that you don't just get out of this?
Well, the final paragraph says more information. Make sure you send a copy of this statute
Yeah.
with.
I just
it.
don't understand what the
That's
purpose
what I'm saying. What
is.
it says here, it says, the information is contained in the notice of rights, which is summarized here.
But why do we need a
Why
summary?
is summarized?
Why
Why is
does-
attached? Because the summary is inaccurate.
I'm moving that we just delete number 4.
Hold on, before you move. I would anticipate that there might be, right now evidently, we're down to 31 programs, local programs. Other programs might start up. They might utilize something like this to assist them in creating their own program. And so that's what this is for, it's just a summary, unless you think that they're gonna get their notice of rights to arbitrate
They
from
have
someone.
to, because they have to serve
Well,
this.
What I was
I understand they
suggesting was-
have to, you're assuming they know.
Yeah, and they don't.
What I was gonna suggest is instead of trying to summarize the notice of rights, why don't we just say, you have to do notice of rights, copy is attached.
That's fine.
You know,
That's
it's-
fine, but I was just
it-
responding to Lee.
Yeah, so I mean, because the last paragraph does stress what, what they need to do with it, but I mean, I agree, it's a waste of time to try and summarize what we already have.
That's
And it makes it difficult because the summary is gonna be inaccurate.
Right.
I don't have a
That's my
problem with that.
point. It's like,
It's fine with me.
so what does that look like then? The
Well, it's
attached
not-
notice of rights
just
after
say-
fee arbitration?
Yeah. Just say, there's attached is the mandatory notice of rights after fee arbitration, then you erase all that, make sure you send a copy, blah, blah, blah. That last paragraph, include the last paragraph.
Especially the blah, blah, blah.
Yeah,
Yeah, that's very
well,
descriptive.
that was the required legalese for it, so.
Okay, is that done?
Yes.
That was my only comment.
That was a lot of comments.
That's what I did.
He's using the term comment like cacti. You know, it's plural.
Okay, so you clear?
Yeah.
Okay. All right, so we're going to 110. Notice of client's right to fee arbitration form.
That'll look good.
There's a couple of like just clarifications at the end on page 111.
What clarification?
Just like adding state bar and program at, just more content. Okay, moving on to number 6 on page 112. Revised fee mediation materials.
I had a question on that one. It's adding the mediation disclosure notification. I don't know that applies here. That's something that attorneys are required to advise and give to their client if they are going into a mediation where they're representing the client. Because that was the whole point of the disclosure was, if I, as your lawyer, am recommending mediation, you need to know because of confidentiality, maybe you can't sue me, and these things. I don't know that that was intended to apply to a situation where the client and the lawyer are mediating against one another. So in essence, who would give this mediation disclosure? Maybe, I guess if either party is represented by a lawyer, then maybe they would have to provide their client with that. But as between the lawyer and the client, I don't think that form applies.
I don't understand what you're saying.
We are adding in these guidelines that they have to give the new required mediation disclosure notification acknowledgement that went into effect earlier this year. That's the form that
Okay,
requires.
I got it,
I don't think that applies here.
So you're saying that it shouldn't be part of
The packet.
the
Sure.
package. And I think it should, because that gives the lawyer the heads up that he or she needs to give this, okay? And it helps
That's my
me.
point. I don't think they have to give it.
The disclosure?
Yeah, if they're mediating, the disclosure is intended
no,
when you're
that's cor- okay,
representing
okay.
a client.
Okay, I got it. I got it.
Not when you're adverse in going into it. I don't
Correct.
No, I agree.
Okay, okay. But I think it should be for anything else. Maybe we can, again, qualify it that this doesn't need to be given if it's a mediation between,
I don't think you wanna say that, because if the client is represented by its own independent lawyer in that mediation, then that independent lawyer has to give the
Right.
notice.
Yeah.
So.
Well, I don't know why we would include that in a packet. That's up to the lawyer who's representing the
as a mediator, I would
party in the
want,
mediation.
yeah, but as a mediator, I would want to know that disclosure was given.
But it's not the mediator's obligation.
I
to make
understand.
those stuff.
I did say it was. I said, if I were a mediator, I would want to know that.
Yeah, I just question, I don't think it was gonna apply in most circumstances, and I don't see why we would include it in a packet of materials that we're providing the parties. That was my comment.
Okay, I got it.
I can be overruled.
You can be overvoted, I don't think you can be
Oh,
overruled.
that's true. That's true.
I agree with Ken.
So we're taking it out,
So
leaving it
we're
in?
taking it out?
B.
Okay, the added B will be removed.
Does that affect the change in date?
Yes, where did that come from?
That's whatever action we take today to update, this advisory.
Yeah, I don't think
It
it
looks like we're not taking any action.
No, there's one more attachment,
Oh, for this?
no, there's a bunch of attachments, so the
Oh,
numbering won't be affected.
Yeah,
oh, I
Um,
see.
Do the new code sections need to
Yeah.
be included in the evidence code attachment though? That's the only, I think, George, is that the only other? Do we also wanna modify the evidence code attachment with the new section? That is related to
You lost me. What are we talking
mediation,
about?
but not
So now,
necessarily fee mediation.
the next thing is all these attachments are part of like this. Like now it's A through H.
Okay.
It's coming.
114 has an issue.
All right, so let's just go through each of the what is, the attachments.
And this is something we talked about before, because under Roman numeral 2, qualification of mediators, says mediators must have completed a minimum of 40 hours of mediation training, which is, I thought, what we had agreed to, but in one of the other attachments,
There's 25, right?
it has the guidelines and minimum qualifications, or the guidelines and minimum standards, when it talks about mediators, it says 25 hours, so they're inconsistent.
Okay, well, this attachment didn't have a date on it, so I don't know when it was last updated, but, Nick did send me the fee mediation materials a while ago, including the model rules. They are in here as part of attachment 6, starting on page 19 to 41. So that is probably the most current version of the fee mediation guidelines.
Yeah, that was what I was talking about, page 47 of attachment 8. Minimum standards for mediation, mediators have completed a minimum of 25 hours of mediation training,
Okay,
but this says 40.
okay, so we should adopt that language for this attachment.
I thought 40 was what we had agreed to. when
That's what I
this
thought
Came up a
too.
long time ago, and I've raised this
Well-
a couple times, because now the forms seem to be, some say 25, some say 40.
How much is it in the program that we just are doing?
I think it's
40, right?
40,
Yeah, it's
yeah.
40. LACMA just created a program and it's 40 hours.
That's what I thought. we
25
had that
seems
debate.
light.
Well, the debate we had when this
25.
came up before was, we talked about 25, but all the mediators who were on the committee were saying, no, if you're gonna be a mediator, you gotta do the 40 hours. So
Sounds like some
the group,
self-preservation.
the group as a whole went up with the 40, so that's what I thought we had agreed to, but.
It's 40.
That's what we.
Well, that's what
I
our
remember.
program is 40.
Yeah, the model rules is 40.
So we would probably need then to change the minimum standard on page 47. Does that need to go up to the board then? This is the guidelines and minimum standards?
Can't we just call it a typo and move on?
Yeah, that's in the guidelines and minimum standards, so I think that has to go up to the board.
Yeah.
Unless it's a typo, I mean.
Yeah, see? Could be a typo.
Is there a typo, board approval of typo?
Okay, so are we moving along? Or what, are we still there?
We're trying to determine the typo rule.
Oh, I don't think there is.
What about the minimum standards that you printed out? That were recently approved in 2017, that say 25?
No, that was
No, that's
arbitrator
different. That's for
qualifications. Yeah.
So this one is on the guidelines and minimum standards for fee arbitration. It was updated on mediation, so it has minimum standards for mediation. And minimum standard 2 says that mediators complete a minimum of 25 hours of mediation training, which includes classroom and practical training. And
You might wanna turn that.
These ones, the guideline, what we're looking at, 114, the attachment of the advisory, says meters must equal a minimum of 40 hours. So that's the inconsistency. I thought 40 was what we had approved when we went through this years ago, but
Yeah, 40 matches the model rules for voluntary fee mediation. So the advisory tracks the model rule. It's the minimum standards that doesn't track the.
yeah.
So the model rules say 40, but the minimum standards say 25.
Yes.
So,
And the guidelines for this attachment here on the advisory, the mandatory fee return guidelines for qualification and assignment of mediators has 40.
in
That's
your-
on page 114. Roman numeral 2.
Thanks. Yeah, so I think, yeah, the board would have to update the guidelines to change from 25 to 40.
No typo exception.
Well, I wonder what the board item
Yeah, we'd have to go back and look with it. That was years ago.
said when we changed the model rule from 25 to 40. So maybe staff can take a look at that and
Yeah,
see if,
it's November 2014.
when the model rule was changed, if somehow the guideline was intended to also be changed. So that's something staff can deal with.
Okay.
But I mean, it's fair to say, the sense of the committee is that the standard should be 40 as opposed to 25,
Yeah.
which seems to be reflected in your prior work anyway.
Yes.
But in the meantime, it's not all that inconsistent. I mean, the minimum is
Yeah.
25, but we're recommending 40. We're kind of covered, but I would like to see that
Yeah.
closed. Besides, the courts get a lot of free mediation. The higher that requirement is because they have to go out and do the free mediations for the courts to get their hours. And so it's a benefit. The court resources anyway.
Okay.
That was it on that page.
Don't find anything else too difficult.
Okay, page 115.
So we're striking that, right? We're striking that 115.
Striking what?
We're not putting this as a fee.
This is the one that we decide, this is the one we said was not appropriate. So this disclosure, this page would just be excluded. This is this.
Oh, yes.
Yeah, so that goes away. 116.
Alright.
Are the evidence codes correct?
I believe so.
Okay. All right. Anything on 117, the form letter to be sent? There's a couple of changes on the other part of the letter on page 118.
Well, no, after the meeting out, 11/29, those changes don't.
Oh, you're right, because it's the disclosure form. So we can stat back those changes. Okay, so those changes will be statted back. Page 119. And page 120, same comment, those changes will be rejected and go back to the original, since that form is not being used. All right, on to the fee mediation settlement agreement, page 121. It goes on to 122 and 123. Any issues?
We add the interest thing that we talked about last time.
That was for the model rule.
We should probably do it on this too.
Okay.
Well, immediate settlement. I would think the same would apply, that we'd wanna have, you know, if there's a refund being ordered, that the interest would kick in 30 days after. But then the same issue pops up, if it's a mediated settlement agreement as opposed to another stipulated settlement agreement, and the attorney does not comply with a refund order and it goes up for enforcement. We had that case where if it didn't say interest,
Yeah, they didn't get it.
the court wouldn't do it.
Yep.
So we should, like we did with the stipulated settlement, I think we should add that here.
So that would be in number 2, where it says the parties
Yes.
agree that, and then we'd add interest at 10% per annum,
30 days after.
30 days after. So we can just track the same language. Okay, so we'll add interest on 121, paragraph 2. All right, these are the excerpts from the evidence code that are referenced.
So 122 is in there anyway, but 122 is amended by adding 3A.
But then, I don't think we need to,
Put in 1129.
right,
Well, if these are just
excerpts of,
excerpt
excerpts of,
excerpts, so this is,
excerpts of codes that are referenced, but we're not referencing 1129 anymore.
Well, 1129's out on the next page.
yeah, but 1122, the extent it references 1129 and 1122, that's what the statute says.
No, I understand that, but I'm just saying, do you need to include on page 126?
I would say no.
Yeah, that's all I'm saying.
Right, well, it's-
Yeah,
So we're deleting,
126 to 128.
we're keeping the change on 125, code 1122A3,
yes,
and we are deleting
1129, which starts at
1129.
126
Does that go through 127?
and 8, I think.
128.
Yeah,
Yeah, all of that is gonna be removed. So that's all gonna be stuck. Okay? 129 is the Business and Professions Code, 6203D. Looks good. Starting at 130, clients' rights post-mediation. There's just some wordsmithing on the title of the program. Yep, no changes. 131, acknowledgement of confidentiality of mediation process. We changed the reference to include through 1129.
And you also dropping 1129.
But if we're dropping it, then we'll go back to 1128. So that'll get started. Alright. Alright, we're now on to a new advisory. Number 7, overview of program administrators regarding rights after mandatory fee arbitration. This continues 132, 133 to 134.
This is, had the same issue as that summary before, it doesn't talk about the shaft situation.
Yes.
So we need to- an overview of program, program administrators. Rights after. Isn't this kind of duplicative of the
Yeah.
other one?
Yeah.
I mean, why are
Yes.
we, I'm not sure I get this.
There's another issue with 4 and 627. 4 listed all the attachments that are not referenced in the advisory, and then this one has no attachments, but reference all the legal counsel forms. So I think they got the law. The other one got all the attachments. This one had all the references to the attachments. The other.
Now, can we just delete this one?
And then on the following paragraph, said, in no event may the program require a modification of the award based on an error of law or fact not involving the NFA program apparent on the face of the award itself. 'Cause I've seen a number of awards where, well, I guess that would have been on the face. I mean, there were clear errors. They either had something wrong or by omission, they made an incorrect determination, and that, we bring that up to the attention of the arbitrators when reviewing the award.
So that's the vice chair. I don't think staff should be,
Well, this is to the program, so it's not necessarily
Right.
who's ever reviewing it, it's the program chairs or whoever, either be it at the state bar level or the county bar program, whoever's reviewing the awards.
well, it's the program, it's not the individual, these are advisories, I understand, that go to the program and the staff, not the attorney vice chairs or the lay vice chairs, or the lay panel members. So, I don't know about other programs.
Well, I think they do go to the program chairs and vice chairs or chair committees.
Nobody sent it to me, have I ever been sent it? I thought.
I mean, they're part of the program, so I mean, that's,
As long as I've been with Blackhawk, I've been on, that's why program roundtables are with program staff. It's not any of the arbitrators, so maybe.
well, it's
your
not just
program-
staff though. We get committee chairs and program administrators come to the roundtables. It's not just lay staff people, so.
Okay, well, that's a misunderstanding on my part, but regardless, I don't think this should be changed. I think that is correct. That just like a regular judge can make an error as to law, and then you got an appeal court decides one way or another if it ever goes to appeal. We shouldn't get involved in any of that. Voluntarily, I mean, I've called people and said, are you sure about that? You know, the stipulation for binding isn't attached, and I didn't see anything. Just make sure that those things are in there. And that alerts the person to, oh, shoot, yeah, I don't have a binding stipulation. It's not binding, I should fix that. Or, an error of law, are you sure that, reasonable value is defined as you say, maybe, things like that. But I don't think the program advisory should say anything more than what it does.
Well, on that last one, it's saying here that they shouldn't do that. In essence, if there's an error of law, they shouldn't address that.
Right, I understand that. I'm just saying voluntarily, this should just say what it says.
I mean, I disagree, but I think that, in reviewing state bar awards and county bar awards, I mean, that's something that we raise all the time. If there's, you're looking at the award and there's just a flat out misstatement or legal error there, we bring that to the attention of the arbitrators. Now, we don't compel them to change it, but at the program level reviewing the award, we bring it to their attention that there's this problem here, and you should at least think about it, and then it's up to them what they do with it. But that's part of the review process. I was a little concerned that this is, in essence, says it's not. In no event may it be that, so.
Well, that's like,
You can suggest.
require, I mean, it's, the language seems like in no event should the program
Oh,
require.
okay, all right, yeah, no,
Versus-
okay.
Right,
Suggests.
that's the language I was looking for.
So I think that's the, I mean, we've had a couple of those where like the non-refundable retainer, and they just like, they can't get their head around the fact of what's a true retainer versus
And honestly, we can't require, how can we require anyway?
Yeah, okay, yeah, no, I missed that,
You're
okay.
gonna go to jail, you have to pay $5 if you don't do it.
so if that issue, that one goes away, what about the tone one do you wanna put?
I think I found a place for that.
Okay,
at the bottom of page 159, third line of the last paragraph, insert between committee chair and any program. This should include a review of the tone of the award.
Where are you?
Ideally, program review should consist of initial staff review for compliance, followed by review by the program's committee chair or other committee member who is a lawyer experienced in fee arbitration designated by the committee chair. This should include a review of the tone of the award.
That's fine.
So you just wanna say,
Or you just leave it at that? I mean, what does that mean?
yeah, what is it?
Does that mean like if the tone's, what is, huh?
Don't be mean.
Well, it's like, what is that, I mean, do we need like a EG or a,
Yeah, that's
like
why I
a,
think that needs to be a little qualified. That's the problem with tone.
It's Ken's,
I think my tone is perfect, and I've been, I think that I very first. So,
what do you
Yeah, I
want
was
to say?
I was trying to think what we have in the training outline. I thought we covered that in there.
castigated the attorney.
I don't know what language we use for that.
Second thought, decided not to do that.
It's in the advanced one?
The outline, yeah.
I mean, we do
Is that on the
in our
website? Yeah.
training, we do in our training tell the arbitrators to make sure it's not personal, to keep a professional and civil tone in the writing. But if you're gonna put it here, I think you need to say a little more than just tone.
You just said it. I move to put your words on there.
And remember my words.
They're on, yeah, I mean, I forget how we phrase it in the, but yeah, that's.
That could have all sorts of, definitions of it.
Okay,
Do we have a
so-
copy, if we got the
No, it's
advanced,
not.
however we have it phrased on there, it would probably be worth. Then I had a question on the last line before conclusion,
Yes.
something about contacting the presiding arbitrator to designate, what is that? I've never had that happen. The last line above conclusion, if they don't have somebody qualified, they should request the assistance of the state bar presiding arbitrator, who will then delegate those awards to experienced fee arbitrators for review. I don't know that that's in the rules, and I've never had that come up.
We've never referred anyone to.
And I'd rather not take on that responsibility.
Did you want to delete that sentence?
I think we should delete
Yeah.
that sentence.
Yeah,
Would
that's
you?
fine with me.
Okay, that sentence would be deleted
Yeah, sounds good.
Any program that.
from any program down, yeah. So the last sentence on page 4 would be deleted.
Or we could substitute Isabel for presiding
Or
arbitrator.
Anahit. Contact Anahit as you mean at this number.
I'll take both.
For her pleasant tone.
Yes,
Yeah.
she'll review your tone.
Okay, so it's okay to leave this one with, this should include a review of the tone of the award as a closing sentence on these advisory? Or should we move it up to?
Well, if we're gonna amplify it, we could put it in that paragraph where we're talking about the whole review process. Either spot works.
We'll find a place.
Okay. All right, trustees and governors is fine, so we're moving to 161. Number 16. I see no red line changes for this one.
Right, okay.
Any pen changes?
Adding, no, probably, I mean, the only. My view on this is it should be as consumer friendly as possible. I had this in arbitration with BASF, where and this lawyer was named, and this lawyer wasn't in the firm anymore, so they didn't want it to be in, and the client agreed that that lawyer shouldn't be in anymore. Everybody was on the same page, yet BASF required the client submit an amended request for fee arbitration, deleting that lawyer as one of the respondents. And then the law firm had 30 days to respond to that. And the whole, it dragged it on for, by the time all that all got done, another 90 days went by, and then we ran into the 1-year statute of limitations on the malpractice situation. So, yeah, no, my only concern was, I mean, if you're gonna switch, if you're gonna add or subtract somebody, especially if you're subtracting, everybody agrees, it should be,
Couldn't the panel just find in favor of that?
I would think so, but I know at least one program makes you jump through all sorts of procedural hoops to add or subtract the lawyer. Adding is a such a,
Consumer friendly.
Yeah, but if you're gonna add someone, and he or she is not gonna have notice of it, I mean, I think you should go through some procedural hoops. Cause that attorney who's going to be now named as a responsible attorney needs to get notice of what's going on,
Yeah.
defend himself or herself, participating in the proceedings.
We're talking about the.
dropping
one that's
someone.
Being resolved.
I understand,
Yeah.
that, exactly, at the arbitration, you just say, not responsible attorney, let's move on. And that's what I would do.
All right,
Anything to do? No. Okay.
not worth a rewrite.
17, on page 164. Couple of words, there's one wordsmith in there. Anybody else? Hearing.
Page one. Yeah.
Don't we need to amend that sentence too? Should it say the former State Bar Committee
Sure.
on Andy?
Sure.
Previously known as.
The now disbanded Committee on State Bar Fee Arbitration?
Also, maybe in the conclusion, we just say, like where it references the state bar, just since we defined it, CMFA, do we just put that there? Because we're saying it different than we were
So it's
previously,
consistent.
so just as consistent.
So how do you want to reference? Do you want to change that sentence, Ken?
I was being facetious.
Okay, I can't tell.
All right, we're on page 176, number 21. Venue for mandatory fee arbitration cases when attorney seeks to enforce choice of venue clause in fee agreement. I see no changes suggested on paper. Hearing none. Page 178, number 22.
Well,
Oh, you want to go back?
177.
Yep, okay. Back to
State
number
bar
21.
That says the guidelines, minimum standards last amended on May 15th, 2000. Is that correct? I thought we amended them after.
No, that would be, I think, March 10th of. No, this is minimum standards, that's correct.
Yeah.
What was amended was guidelines and minimum qualifications for arbitrators.
Okay. For some reason, I thought we had updated the guidelines and minimum standards after 2010. Could be wrong. I just wasn't sure if that.
So Isabel will just double check the date. If it's changed, she'll change it. If it hasn't, it'll remain as May 15th, 2010. On to 22. Governors has been deleted, trustees has been added. Anything else?
Why are you looking at me?
Because you're the one that has all the like notes typically. You got one coming.
No.
23 on page 180. Duty to notify court and others of stay. Judicial council form notice of stay of proceedings.
Okay. Yeah, this one, the title on the advisory did not match the title on the index. The index title was called Procedures for Handling a MFA Arbitration Where a Participant Has Filed Bankruptcy.
Yeah.
So it does not match this title that's on the actual advisory.
The index title is right.
Right.
Yeah.
All right. So change to index title for starters. So you want to talk about your friend?
No.
No?
I mean, you could add that case site in there, but let's not.
You want to poke the bear? I see no other suggested changes. 24, mandatory fee arbitration with incarcerated clients, suggested procedures, protocol, and administrative tips. This one does have some attachments, it says.
So all I did here was I updated the letterhead because the state bar has updated all its letterhead with the logo and everything. And the previous version of this was on the old state bar letterhead. So instead of putting it on the new state bar letterhead, I just took out the letterhead and had a little notation where the local bar can put their own fax letterhead or whatever letter they wanted to use.
Should we change date just to be like, kind of like the fax number for prison fax number, like insert current date? There's like
we can do that.
Where are you?
like,
Page
No,
I'm still on this
190.
one.
oh, okay. We gotta come back.
Page 185.
185. Oh, okay, 185 for Ken.
Statute of limitations for claims with incarcerated client. I think we have to update that because it says attorney fee is subject to the same statute as contractual disputes, the Lee versus Hanley, and then almost updated advisory now.
Okay.
That needs to be changed. I think the application, because if memory serves me correct, legal disability is one of the tollings under 340.6, and I think incarceration is one of the legal disabilities. So, but that needs to be updated to reflect 340.6. So I just noticed that on the plane down. I don't have draft language for that.
Okay.
But we've got the advisory now that talks about all that.
Okay, so start of paragraph 5 is gonna have to be revised to incorporate.
There's something, yeah, there's language in 340.6 about incarcerated clients, and then I think the tolling also triggers.
Somewhere it's told, but it's only
Yeah.
2 years, you guys got a lot of stuff.
So we'll need to just, I can put together some draft language.
All right, so Ken's gonna have an action item here for this one. All right, 186. Nothing. 187. 188, okay, so we're now to, I was just saying like, change that date, so it's a fill-in versus a date. Okay. So the letter, any questions on the letter? If not, we're at 191, advisory 25, use of stenographic reporters in MFA hearings.
That first sentence just needs to be updated. It says over 2 years, well, I guess it was over 2 years ago. It was many, many years ago, but
Do we want to,
we can just take that out and just say the state bar, blah, blah,
did we
blah,
call it CMFA at some point?
whatever it is.
So we're consistent. Isn't that one of
Sure.
the other ones you had
Yeah.
like?
I would just take out the over 2
Over
years
2
ago.
years.
Yeah, just start that with the. Okay. Number 26 starts on 195, responding to non-party requests for disclosure of mandatory fee arbitration awards. There's a state bar rule, oh wait,
Shouldn't we say the committee continues to recommend this until June 2019?
Ken's being snitty. Word of the week. All right, so we have a state bar rule insertion, or no, we have a deletion of one, insertion of another. The end of that in the footnote. That appears to be,
George had a question about whether this new
so
case.
on 199.
Yeah, so George jeopardized everything, and he had a question.
George?
It's when there's, upholding confidentiality, still the way it was with Gilbert and NCAA, or when the Supreme Court changed that in 2017, Williams versus Superior Court, and reinforcing for doing that. And reading Williams a few days ago and reading these two paragraphs, I'm not sure how it fits in A. I think I'd like somebody else to think about it. So reading Williams, I'm not sure if these two paragraphs are 100%.
I have another.
Oh, 196, probably not. I think you're good.
So let me give you a quote from Williams. To the extent prior cases require a party seeking discovery of private information to always establish a compelling need without regard to other considerations articulated in ill, may disapprove. So,
Yeah, but you're taking it, because I'm looking at it too.
okay. Now that's just so long jeopardizing these, and I'd be happy to take this out of the act. I just
Well,
wasn't clear.
I don't think it does, because evidently it's limited to private attorney general actions. That's what that case appears to limit it to. And the court even says, in PAGA actions, blah, 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 this is what we rule. And so I don't think it affects anything else but those types of actions. Just by those languages of the case. Unless, they meant something else. Which often they do. So we're on page
199.
199. getting to the court. They're saying that that's what they're only referring to. I got, actually. Because I'm tired of saying that. We granted review to consider the scope of discovery available for PAGA actions.
Hmm?
Did you have something to say?
No, I couldn't get that microphone turned on and I can't get this one turned off. I was just admiring the quality of that relationship.
So I guess the motion is that there are three areas that that committee members are gonna look at. And once Isabel has the updates on whether a change is necessary or not, are we saying that we're gonna allow her to make the modification?
So let's take them one at a time. So with respect to arbitration advisory number 25, let's assume Heath and Roy look at the case and
There's no change necessary. Then
You will deem that program advisory
approved. Yeah.
I think it's 26, isn't it?
Well,
26.
yeah, but we're dropping it from, so it's.
Yeah.
It is now.
If
we
recommend a
yeah.
change,
Current
be
26.
There is
considered
a
at the next
change,
meeting.
it should probably come back.
Yeah, if there's a
It
change, we're
requires
gonna have to
language.
look at it.
Well, why can't it just have language that says,
Lee? My ride is leaving. I gotta go with it.
Okay.
Thank you,
I
one
know.
and all. It's
Thank you,
been a
Joel.
pleasure. Talk to you all soon, I
Okay,
hope.
talk to you soon. Thank you.
How about Joe?
can we just decide on some very simple language like, also keep, in mind or aware of Williams or Superior Court, we could just add that?
Or see
It's very
also.
simple. Yeah, see.
I wouldn't be comfortable until we see what, if any changes are
I
necessary.
mean, in the event that Williams does in fact have any bearing on, our program, we could put,
We need to
you know,
talk
see-
about it at the next meeting.
So when you guys are looking at it, look at headnotes 33 and 34.
okay,
I think that's where I'm confused, that's where I'm confused.
okay.
Okay, in connection with current advisory 26, which will now become 25, in the event no action is necessary, because the case doesn't impact what we're doing,
Can I just
Yeah,
substitute
go ahead.
your advisory 27 for the one we deleted?
oh yeah,
Can we do that?
oh yeah, you can do that.
Okay, so we'll have a third motion. Instead of approved advisory 27, we'll substitute it for the advisory that we deleted. Right?
Yeah.
Was
Okay,
that,
so the numbers don't change.
The
so
numbers
was
won't
it
change.
Or why don't we just, just because we deleted one, we'll just have deleted. We don't have to renumber from that point forward, otherwise it's a big to-do.
So we'll have like 7, this advisory
Yeah.
was deleted on May 3rd.
Yeah. We'll just leave the number in.
Okay.
the same.
Okay, so that number's reserved. Okay, that works.
I forget it.
All right, back to, okay, the motion on number 26 then is you guys are gonna look at the case. If you determine that case does not impact this advisory, then the advisory everybody's gonna agree the advisory will stand as drafted. If you believe that the advisory needs to change, it'll come back you'll notify Isabel and it'll come back in June.
Okay, I understand.
So move.
All in favor?
Aye.
Okay, anyone opposed? Okay, so that takes care of 26. Should we just do 14 separately then?
Oh, I do it.
What did you say? No, it's all I was saying is from the motion on 14 is that Isabel will make the appropriate,
Rule language insertion.
yeah,
once
rule
it's
language searches once it's
the
approved by
board.
the Board of Governors, or Board of Trustees. No, which one is it? Trustees. Once it's approved by the Board of Trustees.
Once it's approved.
Once it's